How's that? Even our sponsors have to come. All right, great. You should see me in a law school classroom. Really, it's I'm like this all the time. Sorry about the food shortages. I was a little worried about a food riot back there, but cooler heads prevailed. We used to have the Federal Trade Commission sitting. Its annex was sitting across the street before they moved to L'Enfant. And as you know, at Georgetown Law, we have a legendary Taco Tuesday. And I think we had the entire Federal Trade Commission staff sort of poached our territory and ate our tacos. And our students didn't like it, I'll tell you that. So anyway, I thought we were going to have some mischief in the cafeteria that day, but we survived. Anyway, that's probably not the best segue to introduce someone who's been a good friend to Georgetown and to the patent system as a whole, Joe Matal, the interim director of the USPTO. Prior to taking head of the agency, he served as chief of staff to Director Lee and was also an associate solicitor. Certainly he's best known for many of us in the patent community for serving as 10 years as a Judiciary Committee counsel to Senators John Kyle and Jeff Sessions, and is widely regarded as the lead staffer who brought the AIA into fruition. I highly commend and persistently recommend to my students his two-part series of articles on the legislative history of the AIA, which was really a great public service. I know it must have taken a lot of time and effort to write it, and it's been a great service to the patent community. Joe Matal is a graduate of UC Berkeley Law, at the Stanford undergrad, as I recall. He was a clerk at the U.S. Court of Appeals from the Ninth Circuit, and also clerked, I didn't know this until last night, to the Supreme Court of Alaska. So I hope we'll give you a less chilly reception than you received up there. Please join me in welcome Joe Matal.
Thank you, Jay. As Jay noted, I'm the current acting director of the PTO, well, not acting director, almost acting director, but in charge of the agency for the while. It's actually a huge agency. We have 13,000 employees, 3 different labor unions representing our people, 270 PTAB judges, 8,300 examiners, and the operations of the agency are fascinating. And I thought I'd fill the next 30 minutes talking about some of our operational issues, our new time and attendance policy, and going over the last 12 years of, you guys are already laughing, you're in on the joke. So, I have a lot of slides to go through on our past maintenance fees, so we better really start going. No, I asked Alex yesterday what she thought you all would like to hear about, and she said, give your perspective as a former legislative staffer on what's been going on the Hill and what might happen in the future. So, that's what I'm going to focus on. Alex Givens, who runs the Georgetown Clinic, she and I actually overlapped as colleagues on Capitol Hill at the Judiciary Committee, although I'm sure she thinks of me as an old school staffer. I was there so long ago that I worked on the AIA. Actually, when I first started on the committee, the senior Republican on the committee was Senator Strom Thurmond of South Carolina. I don't know if any of you remember him. A man who has spoken to people who have seen Andrew Jackson, believe it or not. So I spent a lot of time on the committee, saw a lot of bills come and go, worked on the great adventure of the AIA. So let me give you my 2 cents on what I think could happen in the next Congress. And none of this is administration policy. None of this is, the administration hasn't taken a position. I'm just giving you kind of my opinion on what's possible. And let me add this caveat that predicting legislative matters is always dangerous. I like to tell the story that when Michelle Lee first became acting director at the end of 2013, the House had just passed the Innovation Act, and I ran into her at an event, and she said, "Joe, I'm thinking of putting together a legislative team to help advise the Hill on this legislation. I, think this could get done, and I'd like to be involved." And I told her, Michelle, they're going to cut a deal early next year, and we'll probably be done before we can even get a team together. So I wouldn't bother. With that note, take my advice or my predictions for what it's worth. But so the last 2 Congresses have mainly focused on the Innovation Act, a bill that the Innovation Act and its similar Senate counterpart, the Patents Act, which I always kind of confused with Title 35. But those bills largely consisted of a series of restrictions on litigation, more precise pleading standards, limits on discovery. And those provisions, as you can imagine, were controversial with patent owners. Anything that increases procedural burdens makes it harder and more expensive to enforce your patent. A lot of those problems ended up being solved in other ways. The Iqbal case finally, at some point, the Judicial Conference decided, you know, Iqbal is a Supreme Court decision, and it applies in patent law as well, and they repealed Rule 18. We now have somewhat higher pleading requirements for patents cases. The way that a lot of the other procedural aspects of patent litigation that were unsatisfying got solved through the courts was through the TC Heartland decision. When you talk to the companies who were advancing these restrictions, a lot of them were controversial, not just because anyone who owns a patent wants it to be enforced as easily as possible, but a lot of it got into issues that had traditionally been handled through the Judicial Conference and not through legislation. But when you talk to people who wanted this legislative approach, the reasons, the trail of abuses that led them to ask for this all seem to lead back to Marshall, Texas. It was practices there, and patent owners would say, well, why are we doing all this just because of Texas? Well, when 45% of all patent litigation in the country is run out of that one district, that's effectively the bulk of what a lot of people in the country know, and that is the patent system for them. And if patent cases are being managed in that district in a way that's unsatisfying for all of those people, they'll demand national legislation. And effectively, you know, at some point, even the House realized, like, why are we doing all these controversial things that, you know, we're running into a lot of headwind on to litigate legislative practices? Let's just fix venue and more equitably distribute the caseload around the country. The House made an effort at that in 2015, kind of ran aground, but then the Supreme Court did it for them in the TC Heartland case. So the the litigation side of patent reform over the last couple of Congresses not only ran into controversy, but a lot of the issues were solved by the courts. The other side of the equation, especially in the Senate on patent legislative reform, has been PTAB reform. I'm sure when Chief Judge Rushke thinks about PTAB reform, he puts scare quotes around the reform part of it. And you know, that legislation ran into its own set of controversies. A lot of the people who heavily rely on PTAB proceedings didn't like some of the changes that were proposed in there. At the PTO, I don't think I'm giving away any secrets to tell you that at the time, this was, you know, under Director Lee, there was some hesitation about some of the legislation being proposed in the Senate. A lot of it was very prescriptive about how the trials are going to be handled. And you know, that legislation also ran into the same kind of, there just wasn't consensus around it. And eventually, a lot of people came to the conclusion, you know, a lot of this PTO could do itself. To the extent there are concerns about PTAB proceedings, let PTO address it. We actually have all the tools at our disposal. If you read section 316 of the Act, there's these very broad grants of regulatory authority to structure the proceeding, and that was done on purpose. The AIA and the PTAB trials were drafted with the recent experience of inter partes re-exam, where we got locked into a model that was dictated by statute, and when things didn't work, when PTO found the proceeding unmanageable, it was, you know, was locked in. You have to get an amendment through Congress. So Congress decided, you know what, we'll try to fix some of the problems with inter partes re-exam, but let's also keep in mind what we don't know, what problems will come up, and let's give the agency the authority to course correct. And just, you know, speaking for PTO, we'd much prefer that route because, you know, if you have an issue, if there's something in PTAB procedures now that you want to fix, if you let us fix it at the agency and that fix doesn't work out, then we have the ability to make further adjustments and continually refine. And that was baked into the design of the AIA, the idea that, you know, issues and contingencies, you know, whoever thought that, you know, federal Indian tribes and hedge funds would be filing IPR petitions, right? I mean, I certainly didn't envision any of that. And, with regard to the legislation, I think that a consensus emerged that, you know, a lot of this is better handled through PTO. So, where does that leave us today? What could we really do with the legislatively? My prescriptions are pretty simple. I think legislation still could get done. There's a long set of technical corrections in the tail end of the Innovation Act, that a lot of which were requested by PTO, little flaws we found in the AIA. Still like to fix that estoppel in PGR. It's been a continual source of embarrassment to me personally. But a less ambitious, more consensus bill is really what could get done in the next Congress. One of the dynamics of patent legislation, and I saw this personally when I was on the Hill, and I think we've seen it since then, is you can get a bill out of committee, but it also has to get through the House and Senate floor, which is run by the leadership. And I assure you, this was always the case when I was there. It seems to have been the case recently. I think it'll be the case indefinitely. The leadership of the House and Senate has no interest in mediating a civil war between the different factions of the patent policy dispute. These issues are complicated. They affect diverse interests that are in everyone's district. Almost every senator or most House members have a little of this and a little of that in their district. They don't want to be forced to choose, and they rarely have any kind of personal knowledge of these issues. Really, to get legislation done, what you need is a rough consensus. And so with that in mind, what could we do other than those PTO technicals, which I'll keep lobbying for? Having followed the debate from PTO and this year, again, a lot of the proposals I've described, were resolved in other ways, or decisions were made to go other ways, and I don't think those will come up again. There are two things in particular that I think are likely candidates, or at least potential candidates for legislation. One is the percolating issue of 101. We've been dealing with 101 ever since the Bilski decision kind of began to unsettle the law. Now we've had about 4 or 5 decisions. And to kind of crystallize the state of the debate and the state of the law, I'd like to commend 2 reports that were done recently. One by the Berkeley Center for Law and Technology, driven by Peter Matal here in the front row, and the other, a report put together by PTO on 2 symposia that we recently did. And what those reports, to kind of summarize and collapse, the direction I think they point is that on the life sciences side, there's an emerging consensus that these patents for medical diagnostic and therapeutic techniques that are effectively rendered eligible by Myriad and Mayo, that was a mistake. And one of the things that kind of stood out from PTO's perspective from our symposium, and again, we're PTO, we're not taking a policy position, we're just collecting views from industry, from stakeholders, and seeing what they think. And on the life sciences side, there really isn't substantial or legitimate opposition to restoring eligibility for these medical diagnostic and therapeutic techniques. In fact, a lot of these things are the cutting edge of science, and personalized medicine is really some of the most innovative stuff. These inventions largely are eligible for patenting in other parts of the world. And after the denial of certiorari in the Sequenom case, a lot of the biotechnology and life sciences people put a lot of hope in that Sequenom cert petition that will get them to revisit Myriad and Mayo and fix this. I mean, I could have told them the Supreme Court never admits it was wrong, and they didn't in this case. But after that denial of cert, I think it's pretty clear now that if you want to fix this issue, really the only avenue is legislation. And to go back to what the leadership is going to look at in terms of whether a bill could go to the floor, the life sciences side, of course, would want this kind of a fix. Could the tech industry live with it? I've never heard of any of the tech companies complaining about getting sued by medical diagnostic trolls. I think it's possible that something could be done on that side. Of course, there's the issue of the Alice case and software as well. What comes out in PTO's report is that there's not the same kind of consensus on that side. That's just a more challenging issue. There's a group of people who would like to repeal Alice, and some of the trade associations have endorsed this point of view. But there's a lot of interest on the other side, some of whose representatives I see here in the audience who feel very strongly to the contrary. And it's possible Congress could do that, but it would be a very contentious debate. So speaking completely agnostically as to what's good policy and what's not, just in my experience as a legislative staffer, on the 101 issue, there's at least the type of consensus you would need for legislation on the life sciences side. On the software side, there's just more debate that needs to be going on. That consensus hasn't arrived yet. I see former Commissioner Stoll in the audience. I know this must be heartbreaking for me to say this, but I just got to tell it like it is. When you have these kinds of powerful interests at each other, opposed to each other on these issues, it would be very difficult, or it would be a challenge to get legislation. As a matter of whether it's technically possible to draft legislation that addresses one side or another, I don't know. That's up to Congress to figure that out. The eligibility issues that arrive for the life sciences side come out of two of the three exceptions that the Supreme Court has identified to eligibility out of the natural law, natural phenomenon. On the software side, it arises out of the third one, abstract idea. So there is that division. I think it's probably possible to write a fix that's driven that way. But given the strength of the interest and frankly, just the importance of not undermining the incentive to R&D and medical diagnostic techniques, I wouldn't be surprised if this is something Congress chose to visit. And again, from my experience as a staffer, it's something that would be possible to visit. The second issue that, again, I'm not even going to predict this would be revisited, but I think that's possible to revisit, is the customer stay proposal that appeared in the legislation over the last two Congresses. This was always kind of one of the sleeper issues. People were worried about PTAB and hedge funds and discovery and joinder and all these other issues, but the two bodies did seem to achieve consensus on how to draft a customer stay proposal. Customer stay is this principle that if a patent owner has sued the end user or the retailer of a product, that if the manufacturer is willing to intervene in the litigation and defend the suit, then you stay the suit against the customer and the retailer and allow the manufacturer to carry the suit. The idea being the manufacturer is more motivated to do so. He has to defend his product in a whole variety of circumstances. And also because the customer just isn't going to understand the technology. The principle exists as a matter of common law, but it's a very ill-defined common law. If you look at the committee report for H.R. 9 from the 114th Congress, it describes how there's just a dog's breakfast of completely conflicting district court law on how the customer stay should be applied. And a customer stay is just a stay. So it's something that's not appealable as part of the final decision. You can only get an interlocutory appeal, and you'll get a mandamus review in the Federal Circuit once in a blue moon, but not nearly often enough to develop a coherent body of law. So just to provide, just to fill the role of providing uniformity, there's definitely room for Congress to legislate. And again, when you look at what was done in the last Congress, it seems like, in that one area, they did seem to achieve some kind of consensus. Another reason why I'd suggest that a customer stay actually might be more relevant now than earlier is because of the TC Heartland decision. Before TC Heartland, venue was the Wild West, and the Federal Circuit literally said, if the personal jurisdiction requirement is satisfied, then venue is satisfied as well. That's literally how the Federal Circuit interpreted. There were decisions after BE Holdings in 1990 where people still tried to argue, well, I can see there's personal jurisdiction, but there's still not venue. And there are Federal Circuit decisions that say, let's be clear, under our jurisprudence, there's no separate test for venue. We've completely read the statute out of existence. You can see why that eventually got reversed in TC Heartland. But now that you do have a test for venue, and it's effectively possible to control, where you get sued in a way that it wasn't earlier, now if a business wants to ensure that it's not sued in any particular district, doesn't build facilities there, doesn't incorporate in that state, it'll also want to ensure that it's not dragged into that district simply because its retailers and end users have been sued. And for some of these big high-tech defendants, for example, you're not going to be able to control where someone takes your computer. You're not going to be able to control a retailer from setting up business in a district where you don't want to be sued. With a codified customer stay proposal, you could at least provide that if someone does sue your customers or retailers, again, part of the way a customer stay works is if your customers or retailers are sued, you file a declaratory judgment in the district of your choice, and that suit against the customers and retailers is stayed. So it effectively allows you to stay out of an unfavorable district if you would otherwise only be forced in there because of your customers and retailers. And just as a practical business sense matter, in a lot of cases, if a company's end users or retailers are being sued, they have to intervene. They can't walk away just for business relationship reasons from those people. So again, just having nothing to do with my ever having worked at PTO, just from my perspective as a legislative staffer, the customer state proposal strikes me as one that's that's viable in the coming Congress as well. So on the issue of venue more generally, when I spoke at IPO in September, the In re Cray case was pending before the Federal Circuit, and I predicted then that I think mandamus will be denied. It's very hard to get mandamus, very tough test. The law is pretty ambiguous. Well, as anyone who follows this issue knows, I was completely wrong about that one. We actually got not only was the district court reversed, but we got a surprisingly comprehensive opinion that really laid down a pretty tight test for venue. I mean, the law of venue for patent infringement cases, I see it now, is you either have to be incorporated in the state or you have to have a building in that state that you own. If you don't have one of those two things, you can't be sued there. And it actually, it's a very, it's very much a brave new world for the issue of patent infringement venue. You have to be a litigator who practiced in the 1980s to really be familiar with what this kind of law means. It was in 1990 that the Federal Circuit, liberalized the venue tests. And, although a lot of venue issues have now been put to bed, I thought if In re Cray didn't, get reversed, then there'd still be the potential for venue legislation. There's much less potential now, but we still do have a very interesting world for patent infringement venue, a world that really doesn't exist for most types of litigation. And in some ways, it's still, sort of less than ideal. I kind of wish Congress had been able to achieve a resolution on those bills that were considered in 2015, because a lot of those provided a more elegant or, more balanced solution for a lot of these issues. The new venue statute does create some difficulties. For example, if you're a drug company and 12 different generic companies file abbreviated new drug applications against you, if they're headquartered and incorporated in 12 different states, you literally have to file 12 different lawsuits under this new venue regime. I'm sure that's not ideal to people. The other really odd part I find of this venue test is I've heard from a number of folks that they're literally considering moving their facilities to get out of districts that they don't want to be sued in. And setting aside everything else about whether people are right not to want to be sued in a particular district or another, it personally strikes me as crazy that patent infringement venue law would drive people's real estate decisions. But that's literally the world we're living in. I've had companies tell me when my lease is up, we're leaving or we're thinking of liquidating this facility. And patent law shouldn't be forcing, driving people to make those kinds of decisions. I can't even imagine what kind of legislative fix would address these issues. But the world we're living in now has some oddities in it that could potentially be addressed. So I've been talking for 20 minutes now. There are three options. I could either open it up to Q&A for you all. I could talk about the Aqua Products case in case you want to reopen, pick at that scab. Or I could talk about the oil states case, which there seems to be a surprising amount of interest in. Is there any kind of guidance from the audience? Do you want to ask me questions? Do you want to hear about what I think about oil states? Anyone? Bueller? Suzanne Michelle, what do you want? What do you want? Oil states, okay. Oil states it is. I knew I could get Suzanne to make a decision. So oil states. So here's a funny little story. Back when I was general counsel for Senator Sessions in the 111th Congress, every Senate office has 2 or 3 kids who work the front desk who field all the incoming phone calls on all the legislative issues that come in. And I get a call forwarded to me, and it's from a retired judge in Alabama who has a patent issue. So they sent it to me, the patent guy. And, it's kind of hard to understand him. I still hadn't gotten used to the accent yet. And about 10 minutes into the call, I realized that the issue that he's having all this trouble with and wants help from a senator on is a land patent issue. He has a neighbor who has land that the title is not clear, et cetera. And, we'd gotten so deep into the phone call, and he was an older gentleman, and he'd been bounced around so much that I decided, well, I have to handle this myself. And I actually contacted a colleague who worked at the Department of Interior, and we got a copy of the original land patent that this gentleman needed for his neighbor in Alabama. And after that, I told people, as general counsel, I'm Senator Sessions' comprehensive patent staffer. I handled utility patents, design patents, and land patents. It's one-stop shopping. So I've told that story for a while, and it never occurred to me that someone would try to merge those two issues of land patents and utility patents. But if you've read the amicus briefs in the oil states case, people are trying to do just that. I'd highly recommend those briefs. It never occurred to me that we'd get, I think we have nearly 50 amicus briefs filed in this case. What's interesting is how much the case has almost become kind of a Rorschach test for what you think about the Patent Trial and Appeal Board and AIA trials. A lot of the briefs have almost nothing to do with the underlying Article 3 question, which frankly is pretty boring. There's only so much you can read about the English Privy Council. One of the briefs filed, I think it was by Gibson Dunn on behalf of some of the high technology companies, is devoted strictly to the history of the English Privy Council. I'll have to admit, back when we were drafting the AIA and deciding how to structure PTAB trials, we didn't give a lot of thought to English Privy Council practice, and it's kind of terrifying to think that that may have some say into whether these proceedings are constitutional. But I commend those briefs to you, at least for a quick skim, because they are kind of they've also kind of become the patent community's opportunity for a catharsis over the angst on both sides of the debate over PTAB trials. Those of you who are, if there are any board judges in the audience, or Chief Judge Rushke, if you're ever feeling blue about attacks from former Chief Judge Rader or anyone else, I'd highly recommend the briefs that were filed by Volkswagen. Volkswagen of America filed a brief. The Gulf Manufacturers Institute filed a brief praising PTAB trials. And then there was a really interesting one filed by the Taiwan Semiconductor Manufacturing Company. And they all talk about how these proceedings have really benefited them and made it a lot easier to resolve these validity questions. And they get an expert determination, and they get it quickly and efficiently, and all the ways that it's benefited them. A lot of briefs on the other side as well, talking about people who lost their patents who feel like they shouldn't have. But anyway, I've at least skimmed or read the table of contents of all of the briefs now. And having read it all, I will stick by my original prediction. It's going to be a 9-0 in favor of the agency. And I will renew the offer I made at IPO that I'm willing to take bets with anyone in the audience on the outcome. Loser buys the winner lunch in the PTO cafeteria. So you'll have to come to PTO. And I told people at IPO that I've had so few takers on this that I'm offering a point spread now. I'll offer you a 2-point spread. Unless the proceedings are upheld by 7-2, I'm buying you lunch. I will note that Kerry Fries of Office of Patent Legal Administration is such a hardcore believer in his position on this that he refused the point spread, and even if I only win 5-4, he'll buy me lunch. So there are some people who didn't need that temptation. But anyway, it's been 25 minutes now. I feel like I've gone on long enough. So let's open it up for a few questions from the audience. Anyone? It's your chance. Anything you want to ask me about what's going on at PTO? Okay. Well, thank you. You're all welcome to catch me later. I'll stick around for a while and ask me about things in private if you'd like. Thank you all.
Joe, thank you so much for that. Just a programming note, we have a break for the next 15 minutes or so, and then we'll get started with our third panel of the day focused on remedies. Thanks.